My name is David Greene. I'm senior partner of a firm of lawyers, Edwin Co., based in Lincoln's Inn, and I'm head of the Class Action Finance Group. You might know about class actions when you think about actions of large groups in the United States, and the way in which group litigation works, both here and in the United States and increasingly in Europe, is to provide access to justice, access to the enforcement of rights for large groups of people, like consumers, like shareholders, those that are affected by environmental change, in order to be able to gain access to the courts and the enforcement of their rights. Policymakers have recognised the need to ensure that there is a collective process for the court. It was recognised in the last 30 years that the procedures for the court must ensure that individuals can indeed club together in order to bring a claim. The first change was group litigation orders, and those are simply that a claim is commenced and a register is set up, and individuals join the register and then will be represented in front of the court. The procedure is closely monitored by the court, as is the register, and individuals will be chosen out of the register in order to represent the claim. In competition claims, we've had a recent legislative change under the Consumer Rights Act 2015, which came into effect a year later, 2016, and that introduced to our process the US-style opt-out process. Now, that's what you normally think of as a class action, which is opt-out. So that means that the court certifies who is in the claim, and we call that a certification process for a class. And if you're in the class determined by the court, then unless you opt out of the process, you're going to be determined within that class, i.e. the court's decision in relation to it will be binding on you. And that is a fresh process that we haven't previously had in this jurisdiction, but we're just really working out how it's working. So we've had now about 60 years of it, and it's taking off slowly. There have been some cases that have gone right up to the Supreme Court in relation to it, but it is a system working itself out. The new opt-out process, however, only applies to competition claims, and they tend to be cartel claims, i.e. where traders have got together and they've fixed a price, which is unlawful. And you can bring a claim as a result of a finding by a regulator that there has been a cartel. Alternatively, abuse of a dominant position, which means that a trader, a company, is dominant within a particular market, whatever it is, and has been abusing that dominance. And for instance, there have been some claims against the likes of Google or other traders that have dealt with abuse of dominant position. We have had also recently a change in the common law, i.e. the common law is determined by the court, in a case of Lloyd and Google. That was a case brought under a particular provision within the Civil Procedure Rules, 1906, and although the case itself failed, under 1906, the court pointed out various ways in which CPR 1906 might be used for group litigation, and we, with long experience of these things, are looking at how we might be able to use that, particularly for claims for investors. Otherwise, there are changes in other jurisdictions. The European Union has been generally against class actions, particularly against opt-out process. But the Commission has been changing its view in order to bring those into effect. But what does the future hold for us? Well, first thing I'd say about the future is that I think we're going to see a growing number of collectivisation of claimants. And that might be, for instance, in climate change litigation or environmental litigation. Also, I think that we'll see many more data breach cases coming to the courts. So I think we're going to see a broadening of the scope of group litigation going forward. And the question is, how's the court going to deal with that? How's government going to deal with that to ensure that people are entitled and are able to get their day in court, to pursue their claims, pursue their rights, or enforce them? So important in relation to, for instance, environmental issues. And that's the issue in front of the government at the moment is, I think we will still see changes. I think we'll see the opt-out process extended in due course. And I think we'll see CPR 19.6 used quite extensively in due course. That really is for the court. But I think that whatever we're presented with, whatever challenges we've had in the past, whatever challenges we have in the future, we will work a way to bring your claim in front of the court to ensure that you can pursue your rights.